Here's a summary of the May 22, 2025 Supreme Court opinion in the case called Kousisis versus United States, case number 230909. The questions presented in this case are 1. Whether deception to induce a commercial exchange can constitute mail or wire fraud, even if inflicting economic harm on the alleged victim was not the object of the scheme. Whether a sovereign's statutory, regulatory, or policy interest is a property interest when compliance is a material term of payment for goods or services. 2. Whether all contract rights are property. Justice Barrett delivered the opinion of the court, in which Chief Justice Roberts and Justices Thomas, Alito, Kagan, Kavanaugh, and Jackson joined. Justice Thomas filed a concurring opinion. Justice Gorsuch filed an opinion concurring in part and concurring in the judgment. Justice Sotomayor filed an opinion concurring in the judgment. Please note that this summary is read by an automated voice.
Justice Barrett's majority opinion. Held. A defendant who induces a victim to enter into a transaction under materially false pretenses may be convicted of federal fraud, even if the defendant did not seek to cause the victim economic loss. A. To convict Alpha and Kousisis, the government needed to prove that they used the wires to execute a scheme or artifice to defraud, or for obtaining money or property by means of false or fraudulent pretenses, representations, or promises. Par of 343. Under this court's precedent, a defendant commits wire fraud only if he both engaged in deception and had money or property as an object of his fraud. It follows from this rule, Alpha and Kousisis say, that a federal fraud conviction cannot stand unless the defendant sought to cause the victim net pecuniary loss. Not so. The fraudulent inducement theory is consistent with both the text of Par 1343 and this court's precedent. 1. The text of Par 1343 does not mention economic loss, let alone require it. In fact, Alpha and Kousisis' conduct satisfied each element of Par 1343. They devised a scheme to obtain money, tens of millions, from PennDOT through false representations about their compliance with the disadvantaged business requirement. And while petitioners argue otherwise, a scheme may still constitute wire fraud even if the defendant provides something of value in return. To obtain means to gain or attain possession. Webster's Third International Dictionary, 1559, and money or property is no less obtained simply because something else is given in return. 2. Petitioners argue that economic loss is inherent to the common law understanding of fraud, a term that appears twice in the wire fraud statute. But when Congress uses a common law term, the presumption that the term brings its old soil with it applies only to the extent that the term has a settled meaning. At common law, the term fraud had an expansive reach. Its elements and remedies depended on the plaintiff's alleged injury. In contract rescission actions or prosecutions for false pretenses, for example, most courts did not require the victim to show economic loss. Instead, it was sufficient that the victim had received property of a different character or condition than it was promised, even if of equal value. Stated otherwise, it was the deception-induced deprivation of property, not economic loss, that common law courts generally deemed injurious. Contrast the tort of deceit. To have a complete cause of action, the plaintiff must have suffered economic loss. In sum, then, the common law did not establish a general rule requiring economic loss in all fraud cases, so the court will not read such a requirement into paragraph 1343. 3. Petitioners concede that the common law did not require economic loss in every case. But their purported exception, cases in which either the plaintiff received something different from what was promised or the bargain involved an item with unique qualities, lacks a driving principle. At the right level of specificity, anything can be described as unique or different from something else. Indeed, the common law has long embraced a different standard, namely materiality, as the principled basis for distinguishing everyday misstatements from actionable fraud. Today, the court reiterates that materiality of falsehood is an element of, and thus a limit on, the federal fraud statutes. But because Alpha and Kousisis have not contested the materiality of their representations, the court does not resolve the parties' debate about the proper standard for materiality under paragraph 1343. B. The fraudulent inducement theory is neither foreclosed by nor inconsistent with the court's precedent. The court has twice rejected the argument that a fraud conviction depends on economic loss, first in Carpenter v. United States, 484 U.S. 19, and then in Shaw v. United States, 580 U.S. 63. And despite Alpha and Kousisis' contrary arguments, the fraudulent inducement theory does not permit a fraud conviction premised on mere interference with the state's power to regulate. No matter the underlying theory of fraud, CM 43 requires that money or property have been an object of the fraudster's scheme. The money or property requirement also explains why the fraudulent inducement theory does not, as petitioners maintain, collapse the distinction between the wire fraud statute and the statutes that prohibit conspiracies to defraud the United States. See 18 U.S.C. Power of 371 and false or fraudulent statements in federal matters. See Fair 1001. Nor does the theory undermine this court's precedent holding that aside from the honest services exception, Paragraph 43 does not protect intangible interests unconnected to traditional property rights. If a scheme instead targets some kind of intangible interest, for example, a citizen's interest in impartial government, the fraudulent inducement theory is inapplicable. Finally, the fraudulent inducement theory does not repackage the right to control theory rejected in Simonelli. Unlike the right to control theory, fraudulent inducement does not treat mere information as the protected interest. Rather, it protects money and property. C. The fraudulent inducement theory does not risk turning every misrepresentation designed to induce a transaction into property fraud. Instead, the theory criminalizes a particular species of fraud, and the demanding materiality requirement substantially narrows the universe of actionable misrepresentations. And while the wire fraud statute is broad, it is up to Congress, if it so chooses, to change it. Affirmed.
Justice Thomas's concurring opinion. Petitioners Stomatios Kousisis and Alpha Painting and Construction Kopenars Inkios ask the court to add an economic loss requirement to the federal wire fraud statute, 18 U.S.C. paragraph 343. The court correctly rejects that request, and I join its opinion in full. I write separately to address an issue that the court reserves: whether petitioners' misstatements were material and thus actionable under paragraph 1343. When the government prosecutes a defendant for wire fraud under a theory of fraudulent inducement, the requirement of materiality provides the principled basis for distinguishing everyday misstatements from actionable fraud. Because petitioners have not contested that their misrepresentations were material, the court has no occasion to pass on that issue today. But I am skeptical that petitioners' misrepresentations were material. although the court leaves the question of materiality for another day because it was uncontested here. Materiality is an element that the government must satisfy in any federal wire fraud prosecution. Government argues that the standard for materiality in this context is the one this court articulated in Universal Health Services, Inc. Absurcher, United States, ex Arlau. Escobar 579 U.S. 76 of 2016, whether a misrepresentation went to the very essence of the bargain. I seriously doubt that the DBE provisions can meet this standard. This materiality inquiry does not rest solely on a contract's labels. Even in the face of contrary contract language, materiality cannot be found where noncompliance is minor or insubstantial. Universal Health Services, 579 U.S. at 194. A party's actions may reveal that a contract term is not material, even if the contract's language would suggest otherwise. For example, that's right, if the government regularly pays a particular type of claim in full, despite actual knowledge that certain requirements were violated and has signaled no change in its position, that is strong evidence that the requirements are not material. The contracts in this case were for bridge repairs, not minority hiring. There are several reasons to think that the DBE provisions did not go to the very essence of the bargain. First, the DBE provisions were irrelevant to the contract's fundamental purpose, bridge repair, which suggests that they were the sort of minor or insubstantial conditions that cannot count as material. As the Third Circuit recognized below, although petitioners did not meet Penn Doty's DBE conditions, they delivered the requested work and the quality of the workmanship and materials was uncontested. If the DBE conditions went to the very essence of the party's bargain, the failure to meet those conditions presumably would have had some impact on the final work product. But the DBE conditions had no bearing on petitioners' ability to complete their projects. That disconnect tends to support the conclusion that those requirements would not meet the demanding materiality standard this court has articulated. Second, the DBE provisions appear to have been less important than contract terms going to the quality and timeliness of bridge repair, further indicating that the latter went to the essence of the party's bargain, while the former did not. The contracts required Penn Doty to deduct payments due petitioners if the work on the project site was late or unsatisfactory. While the contracts labeled the failure to comply with the DBE provisions a material breach that may result in termination, nothing in the contracts required PennDOT to take any action, let alone to withhold or deduct payment. Third, we have explained that the government's decision to fulfill its end of a bargain, despite actual knowledge that certain requirements were violated, is very strong evidence that those requirements are not material. And similar logic might apply where, as here, contract violations are notorious and widespread. No one contends that the government had actual knowledge of petitioners' fraud when it entered into the contracts. But if DBE fraud is so prevalent that the government would have to assume a significant number of its contractors violate contract provisions requiring DBE compliance, that fact could cast further doubt on those provisions' materiality. Fourth, if complying with the DBE provisions would violate the law, it is difficult to see how representing such compliance would be likely to induce a reasonable person to manifest his assent. Among other things, the DBE program imposes an explicitly race-based classification system, which warrants the strictest judicial scrutiny. Thus, for the program to survive, the government would need to prove that it addresses past governmental discrimination that is concrete and traceable to the de jure segregated system, and that the segregated system has discrete and continuing discriminatory effect. I am skeptical that the government could meet this high bar. While the government has not been put to the test in this case, it appears to have elsewhere endorsed the DBE program's race-based benefits on the ground that minorities represent more than 20% of the population, yet own only 9% of all construction firms and receive only about 5% of construction receipts. Oversight hearing at 41. But proving broad sociological propositions by statistics is a dubious business, and one that inevitably is in tension with the normative philosophy that underlies the Equal Protection Clause. And at least one court has preliminarily enjoined the government's use of DBE goals because the government could not justify the DBE program's discriminatory policies. It is implausible to think that a reasonable person would attach importance to contract provisions that mandate constitutional violations. In persuading the court to reject petitioner's economic loss arguments today, the government has assured us that the essence of the bargain standard for materiality will ensure that federal wire fraud prosecutions cannot be used to target benign, everyday misstatements. Because a demanding approach to materiality is all that prevents an extraordinarily expansive view of liability from rendering the federal wire fraud statute nearly limitless in scope, lower courts should hold the government to its word. Justice Gorsuch opinion concurring in part and concurring in the judgment. This case touches on an old question. What is the difference between a lie and a criminal fraud? Consider an easy hypothetical. In a phone interview, a couple asks a prospective babysitter if she has a criminal record. The babysitter says no, but that's not right. While she has sought to turn her life around, a burglary conviction lurks in her past, one she is too embarrassed to mention. Relying on her misrepresentation, the parents hire the babysitter. Her work proves exemplary and the couple pays her well. Later, though, the parents discover the babysitter's lie. They might be upset and refuse to hire her again. But should the babysitter face federal fraud charges? Of course not. While intentional deceit for purposes of gain ought sometimes to be punished, if all misrepresentations amounted to criminal fraud, thousands of buyers and sellers would be felons. How do courts police the line between mere lies and criminal frauds warranting the law's attention? One important tool is fraud's injury requirement. To prove a criminal fraud, a prosecutor must show that the victim did not receive what the defendant promised. It is a rule that shields people like our babysitter from the prosecutor's sights. And it is a rule that keeps judges from becoming arbiters of good morals. A fraud conviction can mean years, even decades in prison. Before a prosecutor may seek and a court may authorize that kind of punishment, the law demands more than a victimless lie. While right about much else, the court's decision today contains a footnote that appears to spurn fraud's historic injury rule. Under the federal wire fraud statute, the court suggests it does not matter if the putative victim receives all he was promised. So long as he parts with any money or property because of the defendant's misrepresentation, the court seems to say that is injury enough to sustain a federal wire fraud conviction. It is a startling suggestion, one with no mooring in the common law of fraud or the wire fraud statute, and one that risks turning victimless lies like our babysitters into federal felonies. Respectfully, that cannot be the law. The question presented in this case is a narrow one. The parties ask us to resolve whether the federal wire fraud statute, 18 U.S.C. paragraph 1343, requires the government to plead and prove that the defendant caused his victim a net pecuniary loss. Today, the court holds that the answer is no. Congress, the court explains, enacted the federal wire fraud statute against the backdrop of the common law. And at common law, fraud required proof that the victim was injured. But that injury requirement never demanded proof that the victim suffered a net pecuniary loss. So the court concludes, neither does the federal wire fraud statute. On each of those points, the court and I agree. But having dispatched the question presented, the court does not stop there. Instead, the court proceeds to assert that the wire fraud statute's injury requirement is satisfied whenever a defendant obtains a property that a victim would not otherwise have parted with by means of a material misrepresentation. The court's commentary on this score might be easy to miss. It comes only in a brief footnote deep in the court's opinion. And on first glance, the court's remarks might seem innocuous enough. After all, one might wonder if a fraud causes a victim to part with money or property, isn't that necessarily an injury? I worry, though, that initial appearances may deceive and the court's stray footnote could portend trouble. Start with this difficulty. What the court says in its footnote does not square with its reasoning above the line. Throughout the rest of its opinion, the court recognizes that the wire fraud statute's references to a scheme or artifice to defraud and false or fraudulent pretenses, paragraph 343, emphasis added, bring with them the old soil of common law fraud. As a result, the common law doctrines governing the crime of false pretenses, the tort of deceit, and the remedy of contractual rescission all inform, to one degree or another, the meaning of the wire fraud statute. Yet, contrary to what the court suggests in its footnote, at common law, it's the mere obtaining of money or property under false pretenses did not alone satisfy fraud's injury requirement. Instead, common law courts usually demanded proof that a defendant deprived his victim of what he bargained for. By the time Congress enacted the wire fraud statute in 1952, it seems that every American jurisdiction except Texas had adopted a similar rule. Nor is the difference between the court's formulation of fraud's injury requirement and the common law rule a negligible one. To be sure, obtaining money or property by means of a material misrepresentation will usually injure the victim, but not always. To appreciate why, some examples help. As one example in Rex versus Williams, a creditor seeking to satisfy a debt ordered his servant to induce the debtor to hand over 2 sacks of malt by falsely representing that his master had bought them, even though the servant knowingly stated that which was false, and his false statement was clearly material. His actions were not criminal because he merely intended to satisfy the debt, not to defraud the debtor. When facing similar facts, a New York court later remarked that it is difficult to see how a victim would be injured when he is merely cheated into paying what he owed. This example highlights that the traditional benefit of the bargain injury rule is not some vestigial limb. It plays an important role in separating mere lies from criminal frauds and, in that way, reducing the risk of frivolous prosecutions. Just ask yourself, if a putative victim of wire fraud got exactly what he paid for, how exactly is he a victim at all? To support its suggestion that the loss of money or property is always enough to establish an injury, the court relies primarily on a decision from the Supreme Court of Pennsylvania. But even that case does not stand for anything like the rule the court imagines. Not only do the court's common law authorities fail to support its view about the nature of fraud's injury requirement, nothing in the text of the wire fraud statute does either. That statute prohibits using the wires to carry out any scheme or artifice to defraud, for obtaining money or property. As this court has recognized, that language means a prosecutor must prove 1. The defendant engaged in a scheme or artifice to defraud, and 2. The object of the fraud was money or property in the victim's hands. So even when a prosecutor is able to show that the defendant sought to obtain money or property, he must still make the further showing that the defendant intended a scheme or artifice to defraud, a phrase that everyone agrees imports the traditional elements of common law fraud. And, as we have seen, those elements include an injury requirement that is not satisfied when a putative victim receives the benefit of his bargain. Left without common law authority or statutory text to support its view, the court seems to suggest that discarding the traditional injury rule at least might make for good policy. A judicial preference for principled rules cannot displace what is and has long been the law. When we look to the old soil of the common law for guidance, we have no license to plow over what we find there. Nor is the court correct that fraud's materiality element can shoulder all the work traditionally performed by its injury requirement. As this court describes it, fraud's materiality element usually asks if a reasonable person would attach importance to the defendant's lie in deciding how to proceed. And as the examples above illustrate, our fallen world is filled with lies, even material ones, that do not warrant the attention of criminal authorities. Creditors who lie to recover their debts from evasive debtors, employees who fib about their credentials to get jobs, and even babysitters who misrepresent their pasts. In all of those cases, a reasonable person would attach significance to the defendant's lie in deciding whether and how to proceed. In all of those cases, too, the lie is intentional, induces reasonable reliance, and causes someone to part with their money or property. Without the traditional injury requirement, every one of those cases gets swept into the prosecutor's dragnet. Over centuries of experience, common law courts developed a variety of tools to sort venial lies from criminal frauds. In a brief and unfortunate diversion in an otherwise sound opinion, the court casts doubt on whether one of those tools still applies under the federal wire fraud statute. In the process, the court needlessly risks turning the federal wire fraud statute into a weapon for punishing victimless crimes. I can only trust that future courts will recognize that aside for what it is, unsound dicta.
Justice Sotomayor opinion concurring in the judgment. The court today rightly rejects petitioner's request to graft an economic loss requirement onto the federal wire fraud statute. When a defendant tricks a victim out of their money by promising one thing and delivering something materially different, it is no defense to say that the delivered items are of equal economic value. Statutory text, precedent, and history mandate that conclusion, as the majority explains. Common sense, unsurprisingly, points in the same direction. A Yankees fan deceived into buying Mets tickets is no less defrauded simply because the Mets tickets happen to be worth the same amount as the promised Yankees ones. That straightforward conclusion is all that is necessary to resolve this case, and I would go no further. To the extent the majority appears to speak more broadly, I part ways from its approach. As the majority explains, this case turns on the wire fraud statute's property requirement, which limits the statute's reach to schemes to defraud or for obtaining money or property. Although that phrase uses disjunctive language, the court has construed it as a unitary whole. Rejecting petitioner's economic loss theory therefore resolves this case, and I see no reason to go further. The court, after all, granted certiorari to address circuit division on petitioner's proposed economic loss requirement. That is the question presented by the facts of this case. The court therefore has no reason to opine on a class of fraudulent inducement cases distinct from this one, those in which a defendant provides exactly the goods or services that they promised to deliver, but lies in other ways to induce the transaction. A wide array of everyday transactional conduct might fall into that category. Consider, for instance, a babysitter who lands a job by fibbing about how she will use the money for college savings rather than a spring break trip, but otherwise fully and satisfactorily takes care of the child. A used car salesman who closes a deal by falsely claiming another buyer is coming to look at the car later that day, while truthfully disclosing all the pertinent details about the car, or a prospective housing developer who beats out competing bidders by lying about wanting to raise a family in the home but pays the full amount of his bid. On the government's view, each of those cases may well give rise to federal fraud liability, punishable by up to 20 years in prison so long as the jury deems the lie material. Future cases presenting such fact patterns will require the court to confront the outer limits of the federal fraud statute's reach and to decide what satisfies its materiality element. Resolving this case, however, requires no such undertaking. To the extent the majority discusses the viability of the government's fraudulent inducement theory more broadly, I do not endorse its approach. That discussion is not essential to the court's resolution of the dispute before us, and I see no reason to proceed more broadly than necessary. This case presents only a narrow question in part because petitioners have not contested the materiality of their misrepresentations. That concession makes good sense. There can be no real debate that petitioners' misstatements were material. Starting with the contract itself, PennDOT expressly made compliance with federal DBE regulations a material term. That was no boilerplate designation. Out of the 17 warranties set forth in the signed documents, only the DBE requirement expressly provided that failure by the contractor to carry out these requirements is a material breach of this contract, which may result in the termination of this contract. PennDOT, moreover, dedicated an entire phase of the contract bidding process to confirming that its prospective contractor had identified a qualified DBE partner who would provide painting services. Petitioners also had to submit documentation throughout the project's duration to demonstrate continued compliance with the DBE requirement. What is more, PennDOT could not have proceeded with the projects as funded if it had not mandated contractor compliance with the DBE requirement. Federal grants accounted for a significant portion of PennDOT's funding for each project, and those grants were conditioned on DBE compliance. The contract's DBE requirement thus went directly to the viability of the projects themselves, and by extension to the very essence of the bargain. It is no answer to suggest that DBE fraud is rampant. Lots of people do it has never been, nor should be a defense to criminal liability without more. Petitioners would have had similar trouble contesting materiality on the ground that, at some point in the future, the DBE statutory scheme might be deemed unconstitutional. Indeed, petitioners at no pertinent time raised a challenge to the DBE program's constitutionality, and the DBE statutory scheme remains good law, as it was at the time of petitioner's conviction. It should go without saying that the law should not provide a shield from criminal liability based upon personal and unspoken predictions of a law's constitutionality.
Case implications. The Kousisis decision clarifies that federal wire fraud does not require proof of net economic loss, endorsing the fraudulent inducement theory, while revealing significant disagreement among the justices about the doctrine's proper scope. Although all 9 justices agreed on the narrow economic loss question, their concurring opinions expose fundamental tensions about fraud's essential elements. Justice Gorsuch's concern that the majority risks criminalizing victimless lies contrasts sharply with the majority's broader embrace of fraudulent inducement liability, while Justice Thomas's emphasis on demanding materiality standards reflects anxiety about prosecutorial overreach. Justice Sotomayor's preference for a narrow resolution suggests reluctance to address the broader implications for everyday transactional conduct, highlighting the court's internal divisions about how far this doctrine should extend. The decision's practical effects remain to be seen, as lower courts must now apply these principles without clear guidance on several key questions. Courts will need to determine whether Justice Thomas's essence of the bargain materiality test or traditional common law standards control, while addressing Justice Gorsuch's critique of the majority's approach to fraud's injury requirement. The lack of uniformity about limiting principles may create uncertainty for both prosecutors and defense attorneys as they navigate cases involving routine business misrepresentations. Given the potential for circuit splits over the proper application of injury and materiality requirements in fraudulent inducement cases, and the serious penalties involved, this area of law appears likely to require further judicial clarification in future cases.